Yesterday, Friday, the 13th of December 2024, was a truly red letter day in the fight against these medical fascists and to hold these COVID criminals to account. This was in the case of Dr. William Bay versus AHPRA, which was the acronym for the Australian Health Practitioners Registration Agency and the Medical Board of Australia, in the case in the Supreme Court of Queensland, where Dr. Bay absolutely smashed them and won on all counts. This, as I said, is a very significant day. These meddling bureaucrats, these medical fascists at AHPRA have finally been held to account by the Supreme Court of Queensland. This is a truly remarkable decision, and heads must roll at AHPRA. I've said for a long time this AHPRA organisation was out of control, and this decision by the Queensland Supreme Court confirms that. There needs to be mass resignations at AHPRA, and these people need to be held personally account for their malfeasance and misfeasance that they've been engaged in. But firstly, here's Dr. Bay talking with Michael Gray Griffith, celebrating his win.
Protests for freedom of speech, for informed consent, for the right for doctors to speak out against the vaccine. And today, Michael, we have victory because the judge in the Supreme Court of Queensland has declared that not only is my suspension overturned, but it was overturned from the day AHPRA ever tried to stop me from speaking in the first place. It's a complete victory. He's overturned the suspension. He's overturned the investigation. He's even dismissed the proceedings in the tribunal where AHPRA was until today trying to get me for professional misconduct for criticising Chief Medical Officer and Head of the CDC, Professor Paul Kelly. It's all gone. It's all finished. The judge has affirmed that freedom of speech is number one. The judge has affirmed that the doctor is in control of the doctor-patient relationship. The judge has made freedom a legality in this country from this day henceforth.
I don't know how to celebrate more. G'day, mate. I don't know how to. It's incredible. And then AHPRA's having to pay for everything. Is that right?
Yeah. Not only did the judge say that AHPRA has to pay for my costs, but the judge said if there are any costs owing to Queensland, because I sued Queensland as well, right? If there are any costs owing to Queensland, AHPRA has to pay for those as well. So it's fantastic news. Fantastic news.
You've done this mostly by yourself, correct? You've had some legal help, but this was your discovery that you were right.
Yeah. Well, look, I have been self-represented. It's true, Michael, but it's all thanks to the supporters like these people here. Hey, everybody!
Hey, guys!
Everything you've heard has been there to deceive you. And I have been vindicated in court today to let you know, the people of Australia, that you have been lied to by the medical regulator. The medical regulator, AHPRA, has lied to you, and the Justice Bradley in the Supreme Court of Queensland today has declared me 100% correct. I have been unsuspended. My investigation has been set aside. The tribunal has been set aside. Everything has been set aside in favour of the truth. God bless you, Justice Bradley. God bless the judiciary. God bless Australia. We have won.
Now, it's worth remembering this was actually a free speech case. That's what it was about, truly a free speech case. Because the judge was quoted during the hearing of asking AHPRA's barrister. The judge said, "So you think free speech is dangerous?" To which the AHPRA's barrister replied, "Allegedly, yes." So free speech is won in this case, because what this case was ultimately about was, does a doctor like Dr. Bay have the right to make political statements? Does he have the right to express his opinion that what the government is telling us about safe and effective of the COVID vaccines, that he has a different opinion? The AHPRA board said no, he doesn't. The Supreme Court ruled that they are wrong, and he, as a political opinion, he is right to hold that and express that as a medical doctor. So let's just go, I think it's interesting to go through some of the comments, the scathing and damning comments of the judge about what he actually said in this case, in his published decision about the conduct of AHPRA. Firstly, the judge notes here in his decision that the board, that's AHPRA's board, denied Dr. Bay procedural fairness. This is a government regulator denying a medical practitioner procedural fairness, preventing him from doing his work for over 2 years. That's a damning statement. If we go down to paragraph 14, it says here, each notification was about Dr. Bay's conduct at political meetings, in online political broadcasts, or at political protests or demonstrations. None concerning his clinical practice. None made any allegations that Dr. Bay had or was providing any clinical services that failed to meet the applicable professional standards. So there you have it. This was all about AHPRA silencing people that had a contrary opinion to what they were instructed by Big Pharma to sell the safe and effective narrative. Paragraph 17. This is also a very telling comment of the judge. He says that during this extraordinary period of history, talking about the COVID period, various measures were implemented by Australian parliaments and their delegates, and various powers were exercised by executive government. From about February 21, vaccines for COVID-19 became generally available in Australia. Legislative and executive measures were applied with a view of encouraging widespread vaccine use. This is the important part. None of these measures authorised the board to abrogate the right of persons such as Dr. Bay to a hearing before a apparently unbiased tribunal. None authorised the board to deny him procedural fairness. And none extended the board's regulatory role to include protection of government and regulatory agencies from political criticism. So this was the case of AHPRA going beyond the powers that they are given by the Parliament, acting outside those Parliament in a malfeasant way. These people must be held to account. And to show some of the skullduggery that AHPRA were involved in, just go down to paragraph 19. It says here in paragraph 19, the board asked the court to dismiss Dr. Bay's application for review and to hear and decide its application separately and before hearing Dr. Bay's application for review. It says, throughout the period when the board adopted this approach, it had the evidence that ultimately showed the board's suspension decision could be set aside. And he goes on here at paragraph 20. The evidence eventually brought by the board revealed other unsatisfactory features of their conduct in dealing with Dr. Bay. Unsatisfactory features. It goes on here. As the above brief recitation shows, their combative approach towards Dr. Bay continued in this court. It continued long after the end of the, quote, extraordinary period in history that the board contended explained its conduct towards Dr. Bay. Complete clean out of AHPRA is needed. I have a couple of the other paragraphs in this decision, page 62. So paragraph 62, which says here, basically explains what Dr. Bay's crime was, right? It says, you are advocating adverse views in relation to the COVID-19 vaccine and its efficacy, which run contrary to public health directives which are designed to protect public health and safety. And finally, the most damning criticism of AHPRA's conduct is in paragraph 107 and 109, where the judge says at 107, on the final day of the hearing, the board and AHPRA tendered the critical evidence revealing errors in their suspension decision. It was produced to the court in an affidavit from Mr. Frollo, affirmed the day before. No explanation was provided for the delay in disclosing this material. He goes on here, paragraph 108, paragraph 108, An earlier examination of the 5 notifications, the agenda paper, and the decisions and actions documents would have revealed that the board had acted beyond the power conferred on it by Parliament. The board and AHPRA had the means to identify and understand that the suspension decision could be set aside by Dr. Bays without application for review. And at 109, rather than reveal or act on this information, from February 10, 2023, they sought to prevent Dr. Bay from having his application for review heard. That is simply not good enough from a government regulator and government agency. And then at paragraph 15, this is the one, this paragraph here, paragraph 15, is why every member of AHPRA needs to have their resignation on the minister's desk by 9 o'clock on Monday. At paragraph 115, the judge wrote, "It might be difficult to characterise the conduct of the board and AHPRA as anything less than profoundly unsatisfactory. You can't get more damning criticism than that." And he actually went on here. The board and AHPRA submitted that the board made the suspension decision in the context of an extraordinary period in history. This is true. However, I reject their submission that it cannot be suggested that the board, AHPRA, and the board chair were, quote, not acting diligently in accordance with a genuine belief that action was required. Not acting diligently. That is what the court found of AHPRA's conduct. And at paragraph 117, the rush to judgment by the board might explain the serious errors made. There was no satisfactory explanation for defending the suspension decision after Dr. Bay filed the application for review. The judge says here, it indicates an animus towards Dr. Bay that is in tune with the apparent bias that contaminated the original decision. Well, animus is not a word that we often use, but the judge has used it. When you look up what animus actually means, it's prejudice or often spiteful or malevolent ill will. So what the judge has said here, that these board members of AHPRA, government bureaucrats, have displayed towards Dr. Bay a prejudice and often spiteful or malevolent ill will. These people should be sued personally for their conduct. Dr. Bay has gone for over 2 years without income because of this. Patients have suffered, Australians have suffered because of this AHPRA board acting, as the court found, with prejudice and often spiteful or malevolent ill will. And then it comes down to the costs of this, in this case. And what did the judge say about the costs, about who should pay the costs of these legal challenges? We go down here, this is in paragraph 133. The steps, now remember that AHPRA are a government board, so these people are not paying the charges themselves. They just simply bill this off to the taxpayer. It says here, the steps in the proceedings could have been avoided had the board acted more like a model litigant and promptly identified that the decisions were affected by apprehended bias and a denial of procedural fairness. Had that happened, most of the costs incurred by the parties and all the delay in the proceeding likely could have been avoided. Now on that, these AHPRA board members should be held personally liable for the costs. Why should the taxpayer have to fund and foot these bills, these legal bills, because AHPRA acted so negligently and so recklessly and with such bias and malevolent intent? So there has to be action against these people. And Over 2 years ago, I stood with Dr. Bay outside AHPRA's office in Queensland, up in Brisbane. Even though I wasn't a elected member of Parliament, I'd lost my seat then. I knew of Dr. Bay, and I wanted to show my support to him, because what was happening to him was a gross injustice undertaken by the Canberra Swamp. And there was one single member of the Liberal Party, the Labor Party, or the Greens or the Teals that were prepared to stand up and support Dr. Bay and call out this injustice that was being inflicted upon him by government bureaucrats. They were all hiding under their desk, as they did with everything about COVID. And at that time, you listen to the speech, I called out that the AHPRA board should resign.
So I am today calling on every single board member of AHPRA to resign. They should resign in shame, and they should admit that they have done completely wrong, and their policies of suppressing free speech, as it always does throughout history, has led to a disaster. Yes! So I stand here proudly with Dr. Bay. I haven't met him before today, but I followed him. And I saw a man of bravery and courage that's prepared to put his Hippocratic oath before his own personal financial deeds. Public is going to be quiet. Every day, more and more people are waking up. There is a tsunami of data that is going to swamp these people. My advice to them, resign today before you are forced out by the people.
Well, 2.5 years ago, I was exactly right. There must be action taken against this AHPRA board, these board members. There should be investigation to see if they are charged with malfeasance or misfeasance, and every single one of them should have their resignation on the minister's desk by 9 a.m. Monday morning.